I'm on page 792 of the Regulatory Guide to the Reference Guide to Regulatory Compliance by the ABA in BSA AML, talking about the prohibition of providing accounts for foreign shell banks. Covered institutions may not provide correspondent accounts to foreign shell banks, including establishing, maintaining, administering, or managing such correspondent accounts. Covered institutions must take reasonable steps to ensure that correspondent accounts provided to foreign banks are not used to indirectly provide bank services to foreign shell banks. C. Covered institutions may provide a correspondent account or banking services to a regulated affiliate. 4. Covered institutions, except for brokers or dealers registered with the SEC, must maintain records of the foreign bank's owners and agents in the United States designed to accept service of legal process. A covered institution does not need to maintain records of owners of any foreign bank that is required to file a Form FRY7 with the Federal Reserve. 5. Covered financial institutions may meet their compliance responsibilities by requesting a certificate or recertification from the foreign bank at least once every 3 years. 6. If, at any time, a covered financial institution knows or has reason to suspect that any information provided on a certification or recertification provided by a foreign bank is no longer correct, it must request that the foreign bank correct the information as appropriate. 7. If a correspondent account was established after October 28, 2002, and the covered financial institution has not obtained a certificate or recertification within 30 days after the account was established, and at least correspondent account counts with such foreign bank within a commercially reasonable time. 9. If a covered financial institution seeks to verify information from a foreign bank but has not received information within 90 calendar days after the date of undertaking the verification, the financial institution must close the correspondent account of the foreign bank and not permit transactions in such account other than to close it. 10. Once a correspondent account is closed due to the failure of a foreign bank to provide recertification, recertification, or verification information, a financial institution must not re-establish the closed account until it obtains from the foreign bank the certification or recertification as appropriate. A covered financial institution is not liable to any person or any court for transmitting a correspondent account in accordance with the regulation. 12. Record-keeping requirements. A financial institution must keep the original of any document provided by a foreign bank and copies of all documents relied on by the financial institution for 5 years after the date the financial institution no longer maintains a correspondent account for the foreign bank. 13. A summons or subpoena of foreign bank records. A. On receipt of a written request from a federal law enforcement officer for information required to be maintained in a covered financial institution, the financial institution must provide the information within 7 days of the receipt of the request. B. On written notice from the Secretary of the Treasury or the Attorney General of the United States that a foreign bank has failed to comply with the summons or subpoena, or that proceedings have been initiated in a U.S. court contesting such summons or subpoena, a financial institution must terminate any correspondent relationship with the foreign bank within 10 business days. C. A covered financial institution will not be liable to any person for terminating a correspondent relationship under this regulation. Failure to terminate an account relationship in accordance with this section can subject a financial institution to civil penalties of up to $10,000 per day until the account is terminated. C. A covered financial institution will not be liable to any person for terminating a correspondent relationship under this regulation. Failure to terminate an account relationship in accordance with this section can subject a financial institution to civil penalties up to $10,000 per day until the account is terminated. Due diligence programs for correspondent accounts for foreign financial institutions. So this is due diligence for your correspondent account. Where was I? Okay, a covered financial institution must establish a due diligence program that includes appropriate, specific, risk-based policies, procedures, and controls to allow a bank to detect and report an anti-money laundering activity involve the corresponding account for a foreign financial institution and to report any suspicious transactions. The due diligence program must be part of the bank's AML program and must include procedures for determining whether any such correspondent account is subject to enhanced due diligence. Anyway, procedures for assessing the money laundering risk presented by the correspondent account based on the consideration of factors such as the nature of the institution's business and markets, 2, the type, purpose of, and anticipated activity of the correspondent account, and 3, the nature and duration of the covered financial institution's relationship with the foreign financial institution. 4, the AML and supervisory regime of the jurisdiction that governs the charter or license of the foreign financial institution. And 5, information known or available to the covered institution about the foreign financial institution's AML record. 3, the financial institution must apply risk-based procedures and controls to the correspondent account. These procedures and controls must be designed to detect and report known or suspected money laundering activity and must include a periodic review on the account activity sufficient to determine the consistency with information obtained about this type, purpose, and anticipated activity of the account. Special procedures. If the financial institution's due diligence program should detail the special procedures undertaken when due diligence cannot be performed, including when an account should be refused or suspended and when a SAR should be filed. Enhanced due diligence 5. Enhanced scrutiny of foreign correspondent accounts owned by a bank that has an offshore banking license. 2, a banking license issued by a foreign country that has been designated as a non-cooperative with the international AML principles by an intergovernmental group of which the United States is a member. Or 3, a banking license issued by a foreign country that has been designated by the Secretary of the Treasury as warranting special measures due to concerns about money laundering. B, enhanced due diligence includes Roman numeral 1, obtaining information on the foreign bank's AML program to assess the risk it presents, and Roman numeral 2, monitoring transactions to and from the account in a manner designed to detect money laundering and suspicious activity. Roman numeral 3, obtaining information on any person with authority to conduct business through any payable through account and the sources or beneficial owner of the funds in such account, payable through accounts or accounts through which customers of the foreign bank can conduct banking activities either directly or indirectly, and 4, obtaining information on foreign correspondent activities if the foreign bank allows other foreign correspondents to conduct banking business through the correspondent account, and assessing and mitigating the risks associated with the activities in the correspondent account. Number 5, determining for each foreign account owner that is not a publicly traded company, the owners of the foreign institution, and the extent of each owner's interest. 6, effective dates. A, due diligence rules. Roman numeral 1, accounts open on or after July 5th, 2006 are subject to these requirements as of July 5th, 2006. Accounts open before that date are subject to those requirements as of October 2nd, 2006. Enhanced due diligence rules became effective on February 5th, 2008. If accounts were open before that, they were required as of May 5th, 2008. Bank Secrecy Act Anti-Money Laundering Examination Manual revised in 2010. says A. Banks should establish due diligence policies, procedures, and controls designed to detect and report money laundering through correspondent accounts. To detect and report money laundering through correspondent accounts established, maintained, administered, or managed in the United States or a foreign financial institution. B. Due diligence program should include Roman numeral I, a determination of whether the account should be subject to enhanced due diligence. Roman numeral II, assessing the money laundering risk for the account. Roman numeral III, applying risk-based controls to foreign correspondent accounts reasonably designed to detect and report known or suspected money laundering, including a periodic review of account activity. And the bank's due diligence program should include a risk assessment program for foreign financial institution accounts. Relevant factors include Roman numeral I, the nature of the foreign financial institution's business and the market it serves. Roman numeral II, the products and services offered by the foreign financial institution. Roman numeral III, the purpose of the account. Roman numeral IV, anticipated activity in the account. Roman numeral V, the nature and duration of the bank's relationship with the foreign financial institution. And the purpose of the account. Roman numeral IV, anticipated activity in the account. Roman numeral V, the nature and duration of the bank's relationship with the foreign financial institution. Roman numeral VI, the nature of the AML and supervisory regime in the jurisdiction where the foreign financial institution is located, and if the information is available, the jurisdiction where the owners of the institution are located. Roman numeral VII, any information known or reasonably available to the bank about the foreign financial institution's AML record. D. Due diligence should also include periodic monitoring of the account's activity to determine that it is reasonably consistent with expectations. E. Due diligence measures should depend upon the risk level of the foreign financial institution. F. Enhanced due diligence policies should be implemented for a foreign bank operating under I, an offshore banking license. Roman numeral II, banking license issued by a foreign country that has been designated as non-cooperative with international AML principles by an international group of which the United States is a member. And 3, a banking license issued by a foreign country that has been designated by the Secretary of the Treasury as warranting special measure due to concerns about money laundering. G. Enhanced due diligence should include reasonable steps to I. Ascertain for foreign banks whose shares are not publicly traded the identity of each of the owners of the bank and the nature and extent of the ownership. Roman numeral II. Conduct enhanced scrutiny of any accounts held by such banks to guard against money laundering and report any suspicious transactions in accordance with SAR regulations. 3. Obtain information related to the foreign bank's AML program. 4. Monitor account activity in ways designed to detect money laundering activity. 5. Ascertain whether any such foreign banks provides correspondent accounts to other foreign banks, and if so, ascertain the identity of those foreign banks and conduct due diligence as appropriate. So, I never much read this I didn't know it was so long, the section on foreign correspondent banks, because I never had any relationships of that nature. But I'm reading it now because I'm getting an AKM certification, so I do have to know this stuff. Section D, but it is unusual for a smaller institution to have any relationships of this kind. 1. Due diligence programs for private banking accounts. Again, not a product that's offered by every bank. Due diligence programs. A covered financial institution must, as part of its BSA AML program, implement a due diligence program for private banking accounts that is reasonably designed to detect and report money laundering and suspicious activity. Private banking, generally, it is the provision of personalized financial services to wealthy clients. B. Private bank account is one that meets 3 requirements. It has to have at least $1 million, established for one or more non-U.S. persons who have direct or beneficial ownership of the funds, and is assigned to or administered by a bank officer or employee acting as a liaison between the financial institution and the covered regulation and the direct or beneficial owner of the account. And 3rd,